but I'm going to read it in Spanish because I have it in Spanish. Is that okay with you? Great.
Sure,
Thank
no
you.
problem at all.
Thank you, thank you. So, la profesora Luciana Yeung es doctora en economía con una pasantía en la Universidad de Derecho, en la Facultad de Derecho de la Universidad de California en Berkeley. Tiene una maestría en economía aplicada y relaciones industriales de la Universidad de Wisconsin-Madison. Es licenciado en economía. Es miembro fundador y expresidente de la Asociación Brasilera de Derecho y Economía. Fue coordinadora del curso de pregrado de Economía de INSPER desde los años 2010 a 2018. Su área de investigación en análisis económico del derecho es básicamente en estudios empíricos de derecho. Tiene publicaciones en les diría, en las revistas más importantes nacionales e internacionales, por ejemplo el Journal of Institutional Economics, el IMA Journal of Management Mathematics, en la Encyclopedia of Law and Economics, en Applied Economics, en Economics Analysis of Law Review, Journal of Institutional Studies, entre otros. Es revisora interina del Journal of Empirical Legal Studies, del European Journal of Law and Economics, del Journal of Institutional Economics, del Operation Research and Decisions, del Economic Analysis of Law Review, Journal of Empirical Studies in Law, Applied Economics, entre otras. Podríamos estar toda la tarde leyendo el resumen de la doctora Luciana Yeung. So, Luciana, it's your time. You have, I'm sorry to say that, but you have half an hour for your lecture. So, thank you.
Thank you, Dr. Juan. I'm so glad I'm here. First of all, as always, so sorry I'm speaking in English. I really feel very shameful about that, but I think that's better for me to speak in English than to speak in Portuñol. It would be terrible to speak in Portuñol. So I'm really glad that from, let's say, this year on, probably, I've been more close to the events of ALACTID, the association here in Latin America. And I know that many Brazilians have been for a long time very involved. And I also thought that it was time for me to focus a little bit more abroad, right, in this sense. And of course, we have so much to learn with each other. I think that we have more to learn, you know, from our neighbors than even probably, you know, from the most traditional countries as the US, as Europe, of course, that we still study a lot European literature, the American literature, but I think that we really have to develop and foster more our knowledge of Latin America, because our problems are just so similar. We just have so much to share in terms of institutions, in terms of laws, in terms of even private practices. So I think that this is very important for us to keep on and probably to develop even more this communication within our continent. So last week, I had a chance to present and to give a talk about one previous paper. And today I will present from another piece of work, which I'm very glad will come up as something, as a publication from ALACTID, right? So we are gathering Professor Juan, Professor Ruben, and us, and many of us from the board, and we are preparing this publication. And the paper I'm presenting today will come up, will appear in this book that hopefully we will have it for you all very soon, and I'm very glad to have it. So the main topic of today's paper was about Brazilian labor courts. Brazilian labor courts, they are just this labor justice in Brazil is something very, either, you know, people usually either love it if you are, you know, trade unions, if you are, you know, worker representatives, or they always also gather some heavy criticisms, usually from employers. And so sometimes it's even like a little bit uncomfortable for us trying all our best to do a very impartial, scientific analysis. And this is actually what we, at the beginning, I had this project with two colleagues, but then later on, you know, things that everybody was just so busy. I just kept on going by myself. So you see that this paper actually have a kind of a weird structure, not following a very traditional structure, at least for the economic papers. But then this is explained because it started as one very empirical paper, and then I started doing some analytical work exercises, and then I came back to the empirical results again. So we are trying to look at labor justice, labor courts in Brazil in a more scientific manner, which there are just so few works in this perspective. Okay. So I'll have to ask probably Ruben to have the control for the PowerPoint, to share the PowerPoint. I have to be the co-host probably, right? Let
me try to help you.
Okay. Okay, now I got it. Thank you. So here we go. And the title for this paper is, the main topic actually is incentives for litigation. As I said, our object here are labor courts, but of course, I'm not only, since I'm publishing it abroad. Of course, I do have some conclusions that might be generalizable, we'll be able to generalize. And actually, it also tries to make some dialogue with some previous international literature, okay, which are related to incentives for litigation. We have all this economic analysis of litigation, this perspective, and then this is a contribution, and a specific contribution in which I look at labor courts, but as an example. So what I'm trying to say is that the results I reach here are not valid only for Brazil or only for labor courts, Brazilian labor courts. I really try to make a point here that this might happen anywhere if the conditions we will see later on are met, okay? So I'll skip my resume because Professor Juan just read it before. So we'll start with one main question, and which somehow tries to make a connection, relation, and dialogue with the international literature, which is it possible, since we in a judicial process, in one litigation, there is always at least one winner and one loser, right? Is it possible that it might be interesting for both parties to always litigate? Because, when you come out from a court, there are usually a winner and a loser, and sometimes even both parties are unsatisfied, right? Dr. Juan is a judge, he knows very well, always there will be someone who will come up very unhappy from course. It's impossible, as I always teach my law and economics students, it's impossible to have both parties coming out happily by the end of a process, right? There's always someone who will be like crazy like hell because he or she lost the case. So is it possible that both parties will be interested in keeping the process going on, the litigation going on? And I will argue that yes, it is possible that, actually neither one is making an effort to have a cooperative agreement, to try to get out from courts and try to settle down cooperatively, and this might be some problem, specifically in Brazil, because as I will show you next, we do have very alarming numbers in litigations. And I would love to hear about that from many other countries. Professor Horn, later on, you probably I want to know about that in Argentina and then the Latin American countries. I know that numbers are very high in Brazil as compared to Mexico. I just had someone talking about Mexico, and that's just so different. So I had this chapter from Professor Ramsay and Rasmussen. They are pretty well known also in the United States. Ramsayers from Harvard, and Rasmussen spent some time in Harvard and now he's in Indiana. And so they wrote this chapter. Actually, their argument was about is asking whether the United States was a very litigious country. So there's some kind of discomfort between the Americans, that they always think that, you know, probably Americans love to fight, love to have lawsuits. And then they wrote this chapter in 2013, and they gathered this number for many countries compared to 100,000 people. So in the US, you have around 5,800 cases, new cases per year, okay, for each of 100,000 people. In Great Britain, that would be 3,600, 700 more or less. In France, 2,400. In Japan, 1,000, close to 1,800, right? So you have, I don't know, somehow people will say that Asian countries usually have lower rates of litigation for historical, cultural reasons, you know, and there's this kind of argument. So if you look at this number, it seems that the US really have a very high number of litigation. But if you compare to Germany, which actually is known to be a very conflictuous country in terms of law, right? In terms of litigation, you see that actually is really high. But I got these numbers for Germany, not from Ramsayers and Rasmussen's paper chapter, but actually from a private source. Actually, these claimants worldwide is an insurance company, and then they have this executive report giving these numbers more or less from the same period of time. That would be actually 2009, I think. That's these numbers for Germany, and that would be over 12,000 for 100,000 people every year. These are the numbers for, you know, the traditional countries. And actually, if we want to look at these numbers for Brazil, these are very easy, because in Brazil, we do have one official report, which is published every year by the National Council of Justice, the Conselho Nacional de Justiça, we would call it the CNJ, right? So CNJ, since 2004, 2005, it has been issuing this official report every year. Actually, the Conselho Nacional de Justiça, we wouldn't say that it mandates, it has any kind of hierarchical order over courts, but they are a council, right? They're a national council, and actually the president of the main officer of the national council would be a justice of the STF, right? The president of STF. So somehow what CNJ asks and mandates, courts will try to follow. If they don't want to follow, there will not be any kind of official punishment, but, you know, it's better that you follow it as being a national court. So since 2004, CNJ published this report, Justiça em Números, and I follow it every year because of my research, of course, but I got this one from 2017. There is a reason why I got it from 2017. The main reason is because I'm working on labor courts, and by the end of 2017, there was this relatively big reform in labor laws in Brazil. So, and it really decreased the numbers of litigation because it was a big problem. So let's see what we got from the Justiça em Números 2017 with data from 2016. There were 79.7 million pending cases in Brazilian courts in December 31st, 2016. And also close to 30 million cases solved, right? So these were the cases which were solved, sorry for some typo. In other words, if we make these numbers and take into consideration that there are around 200 million inhabitants in Brazil, the population is around 200 million, we will have 0.52 cases per capita, and making the multiplication here, then the mathematical operation here, we would have 52.5 thousand cases for each 100,000 people. If we consider only new cases, because it seems that when Professor Ramsayer and Professor Rasmussen, they made this calculation, they took into consideration only new cases that were filed every year. So if we took that into consideration, we would have a smaller number, but even so, that would be much higher than any other country, including Germany, which is by far the most litigious country in these developed countries, right? Among these developed countries. So it's really crazy. We always had this anecdotal evidence, this kind of feeling that there's just so much litigation here in Brazil, but now we do have the numbers, the comparative numbers. I could stay here like the whole afternoon talking about the details about these numbers, but I just want to make one remark. It is not important for our discussion here, but actually there are just so many reasons for these very high numbers. And some would say that actually from all these close to 80 million cases, there is a whole bunch which is related to cases related to the state. So somehow people are suing, the government, the federal government, or the pension fund system, or very related to public matters. Always tax cases. Now I'm just leading one huge project at INSPER to discuss specifically about tax cases. But anyhow, we could try somehow in the future to look at only private cases, right? But I don't think that this is what the other authors did. So I didn't do it here either. So just have some very gross, big numbers for comparison. So I think that anyhow, these numbers kind of scares us, right? So something probably is wrong. And if we look specifically to labor courts, that would also be the case, right? Like many other Latin American countries, we do have a labor system here in Brazil. So probably the most voluminous courts, the courts which have the higher number of cases would be state courts. We would say the common justice, the state justice, labor justice, and federal justice. So we have these three branches, which are the most frequent and which have the highest number of cases in Brazil. If we look at specifically in labor courts, we also see and we also know that there's a lot of litigation. And this discussion about, as I said before, labor justice in Brazil is something very controversial, right? So either people love it or either people hate it. And since the beginning of year 2000, we had this publication from these three guys here. The middle one is Professor Armando Castelar. He's a very well-known economist, and these two other professors are two political scientists and also very famous, Bolívar Lamounier and Maria Teresa Sadek, which Sadek is a very specialist in judiciary too. So they have this book is actually one book coordinated by Professor Armando Castelar, and I would say that this was the first publication in Brazil showing, especially economists like me, like myself, the importance of courts. So I would say that this piece of work, it was actually a book, right, with several chapters. I would consider that this book had the same impact in Brazil as Ronald Cole's 1960s paper had in the world literature, because for the first time, Professor Castelar would say, hey, economists, we have to pay attention to courts. They are very important to the economy. And by the way, the title of the book was Judiciário e Economia, something like that. So just judiciary and the economy, right? And what they did at that time was something very, let's say, preliminary and simple in the economic perspective, because actually it was a survey. They carried out a survey, and then they interviewed and sent questionnaires for around 600 companies, right? So I just brought one table from this publication, from their chapter, in which The title was something like the perspectives of the company's perspectives about the Brazilian justice, the Brazilian judiciary, right? So they have this whole bunch of questions and asking companies, and usually CEOs or CFOs or, you know, all these executives from small, medium-sized, but also big companies, their perceptions and their experiences with the Brazilian justice. So in a period of 10 years, the question was something like that. Your company in the previous 10 years, how many judicial cases it had faced, right? So we can see that for the 600 companies here, there's a whole bunch of numbers here, but they divided these cases, these judicial cases, in different matters, in different branches of law. So they are labor cases, they are tax cases, they are commercial cases related to breach of contract, they are cases related to intellectual property, there are some others related to consumer rights, and so on and so forth, right? So that would cover 1990 to year 2000. You have these 600 companies, and the question was, how many judicial cases did your company face? And we have the numbers here, right? So, and the interesting thing is that we have one column in which the company appeared as a plaintiff. It was the one to start the case. And the other side, when they appear as defendant, so somebody was suing the company against something. If we look carefully in the numbers, specifically if we start looking by the total cases, it probably is very striking, the cases in labor issues, in labor matters. You see, it's 107,000 cases only related to labor issues. The second place would be commercial cases, breach of contracts, you know, suppliers, and then you have consumers, and then you have taxes, which in Brazil is very chaotic. But even though they are just so far behind cases about labor justice, something must be wrong here. I just can't believe that, you know, it's normal, it's okay to have like 8 times more labor cases than commercial cases. And even more striking is that like the great majority of these labor cases, companies usually appear as defendant. This means some employee, some worker, you know, started some lawsuit against the company. Oh, probably Brazilian employers are just so bad, you know, they just treat their employees very badly. I think that even though we still needed to look at the situation and try to tell some better story and try to make some good arguments. And Professor Castelar and Maria Teresa Sadek and Lamounier, they just took this picture. And of course, they mentioned, you know, that's something that we have to look at more carefully about Brazilian labor justice. So again, this was the first very simple empirical analysis made by economists and political scientists. And we could start looking more, you know, we could start a new chapter in trying to work with empirical numbers. So again, if we go back to that official report I just mentioned, Justiça em Números, they do have chapters on the different branches of justice. And we can look at the numbers. The number there, for labor courts, there would be 1,700 new cases for every 100,000 people, right? There were total in the year 2016, total of 4 million new cases, right? So this is what really what was different from when I heard some colleagues from Mexico. They were telling me that in Mexico in some year there were like around 40,000, right? And we have here 4 million cases. Of course, Brazil is much larger than Mexico in terms of population, but even though it's just crazy, I'm not at all proud about these numbers. I'm very shameful about this number. But anyway, there are around 500 pending cases. I would just say that, as I mentioned, in year 2017, there was this labor reform in Brazil, which somehow made the numbers to decrease a little bit. Nowadays, if you look at the numbers, will be a little bit better, healthier, you know, smaller, but still have just so many things going on. And of course, it is not only It would not be enough for us to talk here today about this all, right? So if we go back into the literature, there is a very classical literature on this, starting from the 70s, specifically on the 80s. I will only bring two pieces of paper here, right? And the main idea behind all this analysis, Professor Rubin told me that there are many students here today, right, listening to us. So I'll try to digest a little bit and try to explain that in a more plain manner. So there is some rationale behind this, which comes from the economic analysis. The main reason for someone wishing or not wishing to go to court is are related to the incentives which they are faced with, right? So people who are deciding, you know, an employee, a worker who is deciding whether he or she will sue his company or her company do have some kind of incentives. And it is also, we could also say that it's kind of a benefit cost analysis. Someone will decide because every litigation, every lawsuit will involve some kind of benefit and some kind of costs, right, for either parties. And then what the economic analysis of litigation literature tells us is that if this calculation in the end will be profitable, there is some kind of net profits for litigation, then people will litigate, or even companies will litigate, because companies are made of people, right? Because people make these decisions. I just wanted to remark, especially for those who are not very familiar, who are still not very familiar with the economic analysis of law. When we talk about incentives in economics, nowadays, I would say 21st century, we are not talking only about money. It is very wrong to think that economists only think about money, right? For many decades, we have been talking about studying things like education, like health, like family, like crime, like law, which are all things totally unrelated to money. We do have environmental economies, we do have health economies, we do have law economies like myself, we do have crime economies, which we know all the time we are talking about things that are unrelated to money or to financial motivations. So let's, for those who are beginners in law and economics, please just skip to the next chapter, you know, because unfortunately, I still listen to that all the time, specifically from lawyers and some judges who are not very familiar to law and economics. We do not talk only about money. So when we are discussing about incentives for litigation, it's not only money that matters, right? There are just so many other types of benefits, so many other types of costs. First of all, time, right? The time that we consume having one very long lawsuit, which is the case in Brazil, for years and years and years, this is some kind of cost, even if you do not have to pay anything to courts, right? So this is the first remark that I wanted to say. So this literature is basically trying to evaluate what are the benefits and the costs related to litigation. And I will start probably to the piece of paper which is known as probably one of the founding papers in this area, which is Puce and Klein, 1984. It is a very well known. There are just so many other papers just to discuss about the results from Puce and Klein, 1984. And there they created this selection hypothesis, right? This hypothesis, which basically I took this quotation directly from their paper. And then it reads like this: where gains or losses from litigation are equal to the parties, the individual maximizing decision of the parties will create a strong bias towards a rate of successful for plaintiffs at trial or appellants at appeal of 50%, regardless of the substantive standard of law. Thus, plaintiff victories will tend toward 50%. So this is why later on, this hypothesis became the 50-50 hypothesis, right? What it means is not very easily to immediately understand what they are saying, but basically what they are saying is that under situations of rationality, and in law and economics, most of the time we are dealing with the hypothesis of economic rationality. People are trying most of the time to make decisions based on benefit cost analysis. I would summarize, it's not exactly this, but I would summarize the rationality hypothesis as something like this. So all our decisions that we make in our daily situations, we are trying to evaluate benefits and costs related to that. Of course, nowadays, we know that there are situations in which individuals are not rational, and specifically the guys from behavioral economics, many of you probably have already heard about that, will tell us and show us which situations people do not behave rationally. But again, against what many people think, behavioral economics is not trying to undermine traditional economics, which is based on rationality. On the contrary, behavioral economists are trying to improve the traditional orthodox microeconomic models based on rationality. Because what these guys are trying to tell us, Kahneman and Tversky and all this, all these guys from behavioral economists, they are trying exactly to identify situations under which rationality does not work. So probably we have to have some other explanation to complement the traditional view. So they are very complementary. They are trying, I wouldn't say myself, but they are trying to improve our understanding of human behavior. And still, in many times, rationality assumptions are still valid. And what they are trying to show us are exactly the situation in which they are not valid. And let's try to make some predictions and some models and some policies to make these things better on, okay? So trying to interpret the selection hypothesis is that litigation will tend to reach courts in a 50% probability of winning by plaintiffs. And also in the situation of appeals, they will also have a 50% probability of win by the appellants. This is the prediction from the selection hypothesis. And the main idea is the rationality. In other words, if you see that you have no chances of winning or very low chances of winning, you have no incentives for litigate. And the contrary, and you will try, if you have very low chances for winning the case, you will try to make some agreement, right? Or you try to negotiate with the other party, and then you have like very small litigation. So I just wanted to show you guys that I have this. I think I was a little bit mistaken about the time that I would have, but it's okay. I just wanted to show you that actually I'm trying, what I try to do in this paper, you have the chance to read when the book comes out, is to get first empirical evidence to show that selection hypothesis might be wrong even under the conditions of rationality. But I will try to show which situations are these, which conditions are these, okay? So I will just start probably, I will skip Cooper and Rubenfeld because they just go in the same direction, rational incentives for litigation, right? And then what we try to do actually, I have this quotation from Daniel Reilly, which is also a very famous scientist and have been also make several contributions to economics. And he's talking about big data. And some time ago, it was like close 8 years ago, big data is like teenage sex. Everyone talks about it. Nobody really knows how to do it. Everyone thinks everyone else is doing. So everyone claims they are doing, but no, actually nobody is doing. But we try, and I try to do it here for this paper to extract some big data, right? So actually what we do is we do text mining. the correct term is to do text mining. And what we do actually is that this decision, most of the judicial decisions in Brazil, they're actually open access. Of course, there would be some cases which are private, secret, but most of them are in public archives, specifically, and even the labor courts. So we go there and retrieve some big amount of data, right? There are some technical definitions about big data. There is actually no number, X number, which tell us this is big data, right? But what we did, so I will just show you what we did. We extracted around 400,000 documents, but we ended up actually with 130,000 cases, close to 130,000 cases from São Paulo, right? So this would be specifically the case for São Paulo. And then we try to look at the numbers. What we saw from to these close to 130,000 cases, that employees, that workers actually won. This is first instance only, okay? I'm not looking the second instance, neither higher courts. 88.55%, right? So there's something wrong here, right? And actually, this number really corroborates the anecdotal evidence. Anecdotal evidence in Brazil would say that labor courts always favor employees. Here we go, right? At least in São Paulo. So what I'm trying to say after with the second methodology, so the 50-50 hypothesis is not observed here, right? So what is the economic explanation for this? I would go on with an analytical model, which of course I will not show you, right? But I would give you my main argument. I will first develop a mathematical model for this. I'll give conditions under which it is interesting for both parties to keep on litigating. Why employers, companies will keep on, litigating if they win only 11% of times, right? Because the numbers that we just saw are this. 11% of the times they win, 11.45. Why they keep on? Why they don't negotiate? Why they don't try, some bargaining? I would say that actually their opportunity costs make them feel it is worth even to lose in 88% of the time and then have these very lengthy trials, and then they can keep this money, save this money during all this time, and make some kind of financial investment. And by the end, they will pay their employees because the judge will tell them to pay, and it will still make some profit on this, because throughout all the time, because the lawsuit is very lengthy, they can make even some kind of profit if they invest this money and save this money somewhere else. So as I said, I will not have the chance to look with you, let's say the proof, right, about this. But in the end, I hope you have a possibility to read the chapter later on, but this is the end of condition. But there will be situation in which it will be profitable for both of them at the same time to continue litigation, because of course for employees, they will always win. But for employers, it is worth to keep their money somewhere else, to save their money. And by the end of the period, they will repay this money, and it will be still very profitable. So both parties will be interested in keep the litigation going on. So it is not interesting to actually settle down to make some kind of bargaining and make some kind of cooperation. So this might also be true for all the situation if the mathematical condition, the analytical conditions that I developed in the paper are observed, and they are not something very extraordinary. So it is very possible that in many other situations, you will have incentives for both parties to go to courts, violating what's the selection hypothesis. So I'm sorry for the hurry, but I hope that even though all this hurry, it was possible for you to enjoy somehow this talk, and hope that you guys have the chance to read about that. Thank you so much.
Thank you, Luciana. It was really wonderful. I mean, you were talking about what happens in my country, what happens with my everyday work. I mean, I'm a labor judge, so I know exactly what you're saying, you know. And I wanted to ask you something because, you know, actually, my paper that we have in our book addresses the opposite situation, because in Argentina, what we have is that people prefer to settle than, you know, to wait for a decision. And we don't have this. I mean, although we do have this kind of a bias or a feeling. I said once that it was like a bias, that people think that they're gonna always win the cases because they're workers or employees. What it struck me that it was that it was really I don't know, it was really odd that people prefer to settle than to wait for a decision. Did you have any thoughts about it?
Yes, so the reasons why, right? So in the model that was later on combined with the empirical analysis, actually one of the key factors that determines this result of preferring to litigate is interest rates, right? So actually, what is the prevailing interest rate in the market, especially for if we are talking, and I give an example here, which is from a bank. So what is the prevailing interest rate that this bank could, let's say, save the money in order to repay the condemnation? And the average number there was around 4.5 years, right? So the duration for the lawsuit would take around 4 to 5 years. And what would be the prevailing interest rate for some capital investments and savings the bank will have instead of paying the agreement immediately? Because if you agree, if you settle down, you have to pay immediately, right? If you could wait, and then you also have the interest rates in courts for the judicial debts, right? If we compare these two rates, you will see that it's going to be very profitable for the bank, the employer, to not, to have the lawsuit going on, because at the end of the lawsuit, actually, that amount, the value of the condemnation will be smaller as compared to what it might gain from saving it somewhere else. This is one factor. The second factor would be, which I do not talk in this paper, is related to also to trade unions, right? What is the perspective and, let's say, the interest of trade unions in participating in under these situations, right? It could either be as having more settlements. Probably there's some kind of social or even economic gains for trade unions if they engage in more agreements. Or in other cases, like in Brazil, it seems that they have no incentives. They, as unionists, they also do not have interest in doing so. And then this is the second variable. Another variable that probably we could see, but then we'll look at more empirically, is to compare the values of agreements versus the value of condemnation. How does that, and I also have curiosity, I don't know, do you feel that the value of settlement in Argentina are usually lower than would be the condemnation, or the opposite? What is your
actually, I don't know. It's just really hard for us to measure that, because sometimes it seems like, they're stealing money. I mean,
okay,
a settlement looks like that, like they're stealing money. And sometimes,
you mean the employer?
Yeah, no. I mean the worker, because
okay,
okay, if they take this to court, they would never win.
Okay.
But people have this. I mean, when I say people, I mean both the employee and the employer had in their heads that, I mean, employers say, I'm going to win. I'm going to lose no matter what. I'll lose. And employees say, I'm going to win no matter what. So sometimes, I drove it to I used it, the Kahneman and Tversky model to to analyze this, but
it's great.
it's really interesting. You know, I would talk to you all day. I mean, I'm tempted to have a Zoom talk with you really soon.
May I just add one? I just remember. I was
course.
talking to some guys from business, and they always look at these theories on organizations, and they say they added something. They say, you know, as an employer, probably in Brazil at least, we don't want to settle down because that will damage our reputation. Because if we start to settle and to talk and to
everybody's
discuss,
gonna sue us.
Exactly. So there's
they
another
tell us
level.
the same thing.
Right.
Yeah.
Right.
Okay. Well, great. Do you have any questions from the audience? I think everything was really clear. Okay. Great. So thank you, Luciana. It was really a pleasure. It was an honor. And it was really great. So we keep on talking about this subject.
Sure, we have to. We talked before, right, on WhatsApp.
Yeah, we did.
We have some research and together. I really want.
About cost of litigation. So when you say that you changed the rule about costs of litigations in Brazil, I remember because you know when I was I went to and then I bought the Conciliação to have a better view. Okay, so
fantastic. Thank you so much.
I'll give the command to my friend Ruen.
Command, no era command, joking. Ok, muchas gracias a todas y todos los asistentes el día de hoy. En nombre de la Universidad Católica del Ecuador, su Facultad de Derecho y el Grupo de Investigación, además de ALACDE y la San Martín de Porres y la Universidad Argentina de la Empresa, son muchas entidades intervinientes. Les agradezco, profesora Yeung, nuevamente. Ha sido una gran presentación. Como siempre.
Gracias.
Isa, y bueno, que pase muy buena tarde. Hasta luego. Muchas gracias.